Hello everyone. Welcome back to our channel, Quickera Global. Changes to UK visa and settlement rules after the 2025 Immigration White Paper. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. On May 12, 2025, the government published a white paper policy document called Restoring Control over the Immigration System. The document proposed some changes to make it harder to move to and settle in the UK, with a view to reducing net migration. A white paper does not, by itself, alter the law or the immigration rules. It puts forward changes the government intends to make in future. Some of the white paper's proposals have now been implemented, while others are still to come. What changes did the May 2025 Immigration White Paper propose? The document covered both high-level principles and specific policy changes. Among its many proposals, 8 were detailed enough to be quantified. That is, civil servants included some rough illustrations of how much they might reduce net migration. These 8 proposals were: shortening the list of jobs for which employers can sponsor a worker from overseas for a skilled worker visa. Jobs assessed as being medium-skilled, RQF levels 3 to 5 would no longer be sponsorable unless the Migration Advisory Committee recommends an exemption and the industry demonstrates efforts to recruit domestically. Ending an existing exemption for social care workers so that employers would no longer be allowed to recruit them from abroad. Exploring a levy on English universities' income from international student fees. Making it harder for universities to keep their license to sponsor student visas by introducing tougher compliance rules. Reducing the standard length of the graduate visa for international students to stay on and work in the UK from 2 years to 18 months. Stricter English language rules, higher standards for those already taking language tests, and requiring the partners of people moving to the UK on work visas to have basic English to qualify for a dependent visa. Increasing the standard qualifying period for permanent residence, also known as indefinite leave to remain or settlement, from 5 to 10 years, with some people qualifying sooner based on criteria to be decided following public consultation. Making it easier for people to come to the UK on certain visas aimed at highly skilled migrants, such as the global talent and high potential. Most of these changes can be made by amending the immigration rules. They do not require an act of Parliament, except for the levy on student fees. Most questions from constituents have focused on the proposal to extend the qualifying period for indefinite leave to remain. See below. There have been no changes in this area yet, but the Home Office has begun its public consultation. The Home Affairs Committee of MPs, which is not part of the government, is also holding an inquiry. When are the changes coming in? There is no overall timetable for the white paper proposals to come into force. So far, the main relevant changes are: an initial reduction to the list of jobs eligible for skilled worker visa sponsorship took effect on July 22, 2025. The revised list will be in place until the end of 2026. The Migration Advisory Committee is reviewing which medium-skilled jobs should be on the list beyond that. Overseas recruitment of social care workers also ended on July 22, 2025. Some liberalization of the high potential and global talent routes took effect in November 2025. Regulations to increase the immigration skills charge came into force in December 2025. Looking ahead, new applicants for skilled worker, scale-up, and high-potential individual visas will need B2 English, a higher standard than the current B1, from January 8, 2026. The changes to permanent residence rules are planned to begin in April 2026. Graduate visas will only last 18 months if the person applies from January 1, 2027, but 36 months if they have a PhD. The international student levy was announced in the 2025 budget at £925 per student per year of study, starting in August 2028. A consultation on the details is underway. Are people on a graduate visa affected by the changes to skilled worker visa eligibility? Yes, graduate visas do not require sponsorship, but cannot be extended. Some people on a graduate visa expected to transition from that visa onto a sponsored skilled worker visa, potentially with their existing employer. Higher salary thresholds for skilled worker sponsorship since April 2024 already made this more difficult. And if the occupation was removed from the skilled worker eligibility list in July 2025, sponsorship will no longer be possible at all. These factors appear to have affected graduate visa holders in medium-skilled jobs in sectors such as transport, dentistry, and prisons. Will migrants have to wait 10 years for indefinite leave to remain? The government announced more details of this proposal on November 20, 2025. The baseline qualifying period for many migrants would be 10 years, but some people will be able to qualify sooner while others will take longer. The qualifying periods will now depend much more on each person's individual circumstances. For example, people in higher-skilled jobs who earn over £50,270 or work in public sector healthcare and teaching roles could still qualify after 5 years. The same goes for people sponsored for a family visa by a British citizen and those on the Hong Kong B-No visa. Volunteering in the community would allow indefinite leave after 5 to 7 years. But those working in medium-skilled jobs would take up to 15 years, refugees would take 20 years, unless arriving by resettlement programs, and non-refugees who secured their visa after illegal entry or overstaying would take up to 30 years. In addition, the minimum requirements for permanent residence would be tightened. People would need more advanced English, B2 instead of B1, and personal income of £12,570 for 3 to 5 years. This includes family visa holders and Hong Kongers. See page 24 of the consultation document. These plans may change following the consultation that runs until February 12, 2026. Which immigration categories will be affected by the settlement changes? Most of them. Even if some groups remain eligible for permanent residence after 5 years, people in those groups, such as stay-at-home parents with no income, might be unable to meet the toughened minimum requirements. People with post-Brexit residence rights under the EU settlement scheme are entirely out of scope of the changes. The consultation asks for views on whether other groups, such as victims of domestic abuse and children who grew up in the UK, should also keep their existing settlement rules. Will people already in the UK be affected? The consultation says, we propose to apply these changes to everyone in the country today who has not already received indefinite leave to remain. This would mean that those who are due to reach settlement in the coming months and years would be subject to the new requirements for earned settlement as soon as our immigration rules have changed. The Home Secretary told MPs that the immigration rules will begin to change from April 2026. This is subject to the final outcome of the consultation, which invites views on whether there should be transitional arrangements to exempt some people already in the UK. The accompanying press release suggests that this might be considered for borderline cases. Will there be changes to settlement rules apart from the qualifying periods? Yes. As immigration lawyer Nick Rollison has said, this would be the biggest overhaul of the UK's legal migration model for 50 years, leaving Brexit aside. As already mentioned, the stricter rules on income and English language ability would affect people irrespective of their qualifying period. In addition, the consultation says that accompanying partners of people on work visas would now need to qualify for indefinite leave to remain in their own right rather than alongside their sponsor. It also floats the idea that those granted settlement might no longer gain access to the welfare system. As a result, they would stay on no recourse to public funds with the right to claim benefits restricted to British citizens. Will MPs be voting on the white paper changes? Unlikely in most cases. Revision of visa and settlement regulations is done through statements of changes to the immigration rules. A statement of changes takes effect automatically without a vote being necessary. To reject the changes, MPs must approve a motion expressing disapproval of the new rules within 40 days. Some MPs tabled such a motion in relation to the July 2025 statement of changes connected to the white paper, but the government is not obliged to allow a debate or vote on the motion, and none took place. There may, however, be non-binding debates, which do not involve a motion to disapprove the rules. MPs held such a debate on September 8, 2025. Certain elements of the white paper proposals, such as the levy on international student fees and any changes to naturalization law, do require an act of Parliament and therefore the endorsement of MPs. That is all for today in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully, the information is useful to you. See you later in the next video. Till then, take care.